Hello everyone, my name is Dawood, student ID 240604661, and in this video I am going to advise you Suleiman on your rights and remedies under the Sale of Goods Act 1979. Following the problems you experience with your furniture delivery from Amjad's furniture store, I will walk you through each major issue, explain the relevant legal rules and court decisions that were held in previous cases, apply those rules directly to your situation, and outline the remedies available to you for each issue. Coming on to the facts, you ordered 25 extra large grey marbles, tables, 100x display velvet chair, and one leather sofa set. After confirming it would not irritate sensitive skins, however, when the delivery arrived, the tables were mixed and incorrect. Several chairs had grease, mark, and scurf, and after sitting on the new sofa, your daughter developed an itchy rash. You contacted the store the next morning to reject the goods, but they told you it was too late. Starting with the tables, you ordered 25 extra large grade marble tables, but you received medium marble tables, wooden tables, and only one correct table. This is a clear breach of Section 13(1), which requires goods to correspond exactly with their description. The strictness of this duty was confirmed in Arcos v. Renaissance, where a minor deviation justified rejection. In your case, the deviation is much more serious as both the size and material differ. Further supports come from Section 31 and 32, which allow a buyer to reject goods when mixed or incorrect items are delivered. In Re Moore and Co., the code allowed rejection even though the goods themselves were correct but packaged incorrectly. Here, the breach is far more substantial. Section 48 of the Sale of Goods Act 1979 provides remedies when delivered goods do not conform to the contract. Under Section 48B, you are entitled to replacement of all incorrect table, and if this cannot be done within a reasonable time, Section 48C allow you to reject the table and obtain a refund. This approach is supported by Harlington and Leinster v. Christopher on the issue of acceptance. Section 35(2) confirms that a buyer only accepts goods after having a reasonable opportunity to inspect them. You inspected them on delivery and rejecting them the next morning, which is within a reasonable period, as academics such as Seeley and Hawley have emphasized. Finally, because this breach concerns a condition of the contract, you are entitled to reject all the table. Under Section 51, 52, and 53, you can also claim damages for non-delivery, including the cost difference for obtaining replacement and any resulting financial losses. Although specific performance under Section 52 is rare, it may apply where goods are unique. Overall, the breach is so severe that your right to reject is extremely strong. Moving to the next issue, X display chairs. Section 14(2) requires goods to be of satisfactory quality. Although you were told the chair had minor wear and tear, the grease marks and scurf you found go far beyond what a reasonable business buyer would accept. In Roger v. Parrish, the court held that even minor defect could make goods unsatisfactory if they affect appearance or value. Similarly, Lambert v. British Aluminium confirmed that X display does not excuse undisclosed defects. Section 48 again applies here. Under section 48b, you may require repair, for example, professional cleaning or replacement of the defective chairs. If this is not done within a reasonable time or without inconvenience, section 48c entitles you to reject the chair or seek a price reduction. This aligns with Bartelt v. Sidney Marcus, where the seller was still liable for defect beyond those disclosed on acceptance. Section 35 protects you since you only opened one box and complained the next morning. This is clearly within a reasonable inspection period. Regarding remedies, if the defects are substantial, you may reject all 100 shares and claim damages. Under the section 51, the cost of purchasing suitable replacement. If the defects are minor, you may instead seek repair, replacement, or a price reduction. Under section 53, legally your position remains strong whichever remedy you choose. Turning now to the sofas. This is one of your strongest claim. You specifically told the sales advisor that the sofa must suitable for individuals with sensitive skin, and she reassured you that it will not cause irritation. This triggers section 14.3 on fitness for a particular purpose. The principle is illustrated in Stington Pigris, where goods must be fit for a purpose made known to the seller, and more closely in Grant v. Australian Knitting Mills, where skin irritation resulted from goods unfitted for purpose. Section on 48 provides the same remedies here. Under section 48b, you may demand a replacement sofa that does not cause irritation. If this can't be provided within a reasonable time or without inconvenience, section 48c allows you to reject the sofa and receive a full refund. This is further supported by Griffiths v. Peter Conway, which emphasizes that once a specific purpose is disclosed, the seller is responsible for ensuring suitability on acceptance. Your rejection the next morning clearly falls within a reasonable period. Under section 35, in terms of remedies, you are entitled to reject the sofa entirely and obtain a full refund. Under section 51, you may claim damages for any additional cost of buying a replacement, as well as reasonable medical expenses and inconvenience. Although specific performance under section 52 is possible, it is rarely granted for ordinary commercial goods. Finally, the store's claim that it was too late for you to reject the goods is legally unfounded. Section 35.4 makes clear that simply taking delivery or briefly checking goods does not amount to acceptance. You contacted the store the very next morning, which court consistently view as well within a reasonable inspection period. Therefore, the seller refusal to accept your rejection has no basis in law. To conclude, Salman, the issue relating to the table, chair, and sofa clearly demonstrate multiple breaches. Essential terms under the Sale of Goods Act 1979. The table breaches section 13, section 30, the chair breach section 14.2, and the sofa breaches section 14.3. You acted within a reasonable time frame under section 35 and therefore did not accept the goods. Your statutory remedies under section 48, 51, 52, and 53 allows you to reject the goods, obtain a full refund, recover damages for replacement cost, and in rare cases seek specific performance. Given the seriousness of the breaches, your legal position is extremely strong. You are entitled to reject all of the faulty goods and claim the appropriate damages. However, despite the strength of your legal argument, the final outcome will ultimately depend on the judge's assessment of the evidence, the credibility of both parties, and the specific facts of the cases. Thank you.